The Federal Family and Medical Leave Act provides job protected unpaid leave for employees for qualified medical and family reasons. The only real distinction between when you can take FMLA leave and when you can take paid family leave, again, is the employee's own serious health condition, which is an FMLA event, but not a paid family leave event. There are different eligibility requirements as far as how long you've been working, etc., for FMLA, and I'm going to show that in a minute. But again, once someone is eligible for both, employers can run that concurrently, paid family leave and New York paid family leave. And here's the important note on that. If an employee is eligible for paid family leave, but doesn't apply for it, and the employer places them on FMLA leave because they're also eligible for that, the time that they're on FMLA leave and were eligible for paid family leave can be deducted from their paid family leave eligibility anyway, even though they won't receive the benefits. The point of this is the employee doesn't have the right to say, well, I only want to be on FMLA leave right now. For whatever reason, I don't want to use my paid family leave, so that, for example, once my FMLA leave is over, I can then use paid family leave so I can get 24 weeks off instead of 12 weeks off. Let me try to break down another situation. A spouse is having surgery that is going to require the employee to be out of work. The employee notifies the employer in advance. The employer designates the leave as family medical leave, as they're allowed to do. The employee doesn't have to request family medical leave under the FMLA, that is. The employer can say, well, your leave is going to be subject to the FMLA because you qualify for it. They designate the FMLA leave, give the paid family leave paperwork or information to the employee, but the employee says, well, I don't want the paid family leave, and therefore they don't apply for it. Employer's not obligated or frankly really permitted to apply for the paid family leave for the employee, at least not against their wishes. But even if that happens, the employer can run the FMLA time, and the time that they're on FMLA still runs their eligibility for weeks of paid family leave during that year. Here's a chart of the main differences between paid family leave and Family Medical Leave Act. The coverage is a big difference. Again, most all private employers and employees in New York are subject to the paid family leave program. FMLA, you have to have at least 50 employees before anyone would be eligible to take leave. The eligibility for the FMLA, you have to have worked for 12 months, and you at any time have to have worked at least 1,250 hours in the 12-month period preceding the leave. The New York paid family leave doesn't have any hours of work requirement over the past year or any other time period. Once you've worked the 26 weeks or 175 days and become eligible, then you remain eligible throughout your employment for 12 weeks of leave per year. Employees cannot use paid family leave for their own serious health condition. Otherwise, they can essentially use both forms of leave for the same circumstances, except under the FMLA, caring for a child is limited usually to children under 18 years. That is not the case under paid family leave. You can use shorter increments of FMLA. You can only get paid family leave benefits in full day increments. Under the FMLA, you can require employees to use other paid time off. Because paid family leave is already a paid leave benefit, you cannot require employees to use other paid time off while on paid family leave.